and go in with some first readers. Having said that, I'm going to go a little bit out of order. We have a chairman, Chairman Benton, who his committee meets right now as well. And as many of us find ourselves trying to be in two places at one time. So, Representative Chairman Benton, you want to read the preamble? Okay. We're going to read the preamble very quickly, and then if you'll take a couple or 3 minutes, this gives the members of the committee an overview.
House Bill 69 by Representative Benton of the 31st, a bill to be entitled an act to amend Article 3 of Chapter 4 of Title 48 of the Official Code of Georgia Annotated relating to redemption of property sold for taxes so as to change provisions relating to the amount payable at redemption, to provide for related matters, to repeal conflicting laws, and for other purposes.
Well, I was assigned that bill to Public Finance and Policy, with Chairman Ron Stevens being the chairman. Mr. Chairman, you're welcome to present the bill from your seat, or you can go down there, whichever you prefer.
Right here is fine. Thank you, sir. Thank you, Mr. Chairman, members of the committee. I want to present to you today House Bill 69. 69 is the bill has to do with trying to protect the innocent purchaser of property at a tax sale. When a purchaser buys something at a tax sale, he doesn't acquire 100% ownership interest in the property. The original owner has up to 1 year to redeem the property and retake ownership of it. During this 1 year redemption period, the person who buys the property at the tax sale does not have the right to possess or otherwise use the property he purchased. The property is essentially in limbo during this time. One cost that is not addressed in the current code is homeowners association dues, and who is ultimately responsible for them during the 1 year redemption period. I think there's been one Georgia Court of Appeals case that said the person who purchases the property at tax sale becomes responsible for homeowners' dues at the time they accept the deed. That would be all right if the property is not redeemed. If the property is redeemed, then the person that redeems the property is essentially gotten out of paying his homeowner's dues. He didn't pay his taxes, so he lost his property, but he's come back, and now he's not having to pay the homeowner's dues, which the person that bought the property at the tax sale is having to pay. We've had several cases like this in our state courts in Jackson County. There is a gap in the law, and we'd like to see the law amended to where if the property is redeemed, then that fee is either included in the redemption cost or whatever the committee might want to come up with different than what we have in the bill. Thank you, sir.
Questions from the members? I see none, Mr. Chairman. Thank you. I want to introduce to members of the committee, members of our staff. Tatiana Posada is an intern from Georgia Tech. She just left the room to go tell people in 606 if we're not meeting over there. Jeremy Betts is our policy analyst for this committee. Greg Schwartzberg is our full-time during the session tax lawyer. We're very pleased to have him on board, and of course Rick Ruskell is our attorney from Leg Counsel that has responsibility for this committee from his perspective. In your folder you will find a copy of the proposed committee rules for the next upcoming this year and next year. I give you a couple, 3 minutes to take a look at them. There's very little substance. I don't think there's any substance that changes from last year. Representative Martin, you have a question relative to the rules?
Yes, sir. Mr. Chairman, just on Rule 14 to understand, because I read then 14.1, the open, modified structure and structured rule would be applied to amendments that were brought to a bill or a substitute outside your normal, the chair's normal subcommittee structure. You would apply those three criteria, A, B, and C, to those amendments that came outside the structure of the subcommittee. Okay.
That's correct.
Thank you, Mr. Chairman.
Any further questions? If not, I'll recognize Representative Martin for a motion.
Move we adopt the rules for the 2013-2014 session as presented.
Motion been made and second to approve the committee rules. All of those in favor signify by saying aye. Aye. Opposed, like sign. Thank you. Want to introduce 6 new members of this committee. They are Representative John Carson, Representative Brett Harrell, Representative B.J. Pack, Representative Matt Ramsey, Representative Lynn Riley, Representative Bruce Williamson. We welcome you to this committee. I just hope you didn't get any bad information and think that this is anything other than a very hard-working committee that's going to take up a lot of your time. If you thought otherwise, you're in the wrong room. But otherwise, we really are pleased to have you join us, and we are getting full underway with dealing with the business that comes before this committee. The subcommittee assignments are also in your packet, showing the members, and you will notice that several of you are on 2, sometimes more than 2, at least 2 subcommittees. And the reason for that is our subcommittees are very busy. We have, quite frankly, a few less members than we had last time. Our subcommittees, as you probably know, meet very often. And so that's the reason why some of you are working with 2 and sometimes even 3 subcommittees. Subcommittees in this committee play a very important role. That's where the real vetting of the bills takes place. And I appreciate everybody's willingness to serve on these very important committees. All right, the next item is we will have first readers and assignment the committees and a brief explanation by the author of the bill, House Bill 34, Representative Parsons.
House Bill 34 by Representative Parsons of the 44th and Smith of the 134th, a bill to be entitled an act to amend Code Section 48-7-29.14 of the Official Code of Georgia Annotated relating to the income tax credit for clean energy property so as to include certain commercial geothermal heat pumps with the definition of the term clean energy property, to provide for related matters, to repeal conflicting laws, and for other purposes.
Income Tax Subcommittee, Jay Powell, Representative Jay Powell is the chairman. Representative, Mr. Chairman Parsons, if you're ready to explain your bill.
Good day. There's currently a tax credit for what's termed clean energy property, and it's already in code. There's already a tax credit for Energy Star certified geothermal heat pump systems. Since that bill was originally passed, whenever it was passed, the standard now is what they call commercial three-phase geothermal heat pump system. It meets the same requirements and everything that are currently in the code. And it would just add that, but that's the one that is normally used, I think, for the larger installations, and currently it's not included in the law. We actually passed this exact same bill out of this committee last year. It passed through rules, passed the full House, passed all the way, then went to the Senate, and it passed the Senate, but there was some extra language that was added over there, and it didn't make it back, through the House. But this bill actually passed through the House last year exactly as it's written currently.
Members of the committee have any questions of the author of the bill? Don't see any. Thank you, Chairman Parsons. House Bill 42 by Chairman Sims.
House Bill 42 by Representative Sims of the 169th. To amend a bill to be entitled an act to amend Part 2 of Article 1 of Chapter 8 of Title 48 of the Official Code of Georgia Annotated relating to imposition, rate, collection, and assessment of sales and use tax so as to change the manner and method of imposing and collecting such taxes on certain manufactured single-family structures, to provide for legislative intent, to provide for definitions, to provide for procedures, conditions, and limitations, to repeal conflicting laws, and for other purposes.
Sales Tax Subcommittee, chaired by Representative Ben Harbin. Representative Sims, you want to explain your bill, sir?
Yes, sir. We introduced this bill last year, but we kind of ran short of time on the fiscal note, but we got the fiscal note this year. Basically, what this is for the manufactured housing industry. They're currently being taxed at the retail level when the home is sold, and the financing on that is becoming almost impossible for folks to trying to get the financing done. They have said that by eliminating that tax and the taxing at the 60% of the manufacturer's invoice rate or the amount would be a better taxation method. They're actually going to be paying the tax ahead of time on each dwelling, even though they may not sell it. On the somewhat similar to the way a stick house or a regular home is built now, that they pay the sales tax on the materials at the time. That's what they're asking at 60% of the invoice amount, and that's basically what the bill does, sir.
Any members of the committee have questions for the author? Chairman Powell has a question.
As I understand it, what you're saying is that sales tax is only charged when the manufacturer sells it to a homeowner, is only charged on the materials?
No, it's actually when the dwelling is complete, the sales tax is just like on a car. The sales tax is now levied. Let's say the house is a $10,000 home. It's 7%. There'll be a $700 sales tax fee entered in when they do the financing for that. Now, if it's a $70,000 home, it'll be a $4,900 bill at that time. That's where they're having the problem. You don't see too many $10,000 homes, and what they want to do is go at the invoice value of that home when they put it out to sell at the wholesale rate. The wholesaler is going to be paying the tax. In other words, the manufacturer will be paying it when they build the home, just like if you had a contractor build your home, he pays the sales tax on the materials as he gets it there, and he charges you back that at that time. It's a little hard to understand, but I'll try to make it a little bit easier when I get it to committee. Yeah, it also does collect, and it doesn't. You don't collect it twice, and there's also the fact on a resale that they would be also exempt on a resale because they've already paid the sales tax one time.
Chairman Martin has a question.
Thank you, Mr. Chairman. Chairman Sims. So basically, what you're trying to avoid, I mean, you are cutting the amount of tax from 100% to 60%.
Right.
And I was going to ask you where you come up with that number. We'll do that in subcommittee. But what you're trying to accomplish here is to push the cost into the manufacturer, the cost of goods sold for the product. Then when they buy the home, they're really going to buy it now for $75,000.
Right.
But they can finance the whole 75 because it's going to look like the cost of the house.
Right.
Is that what you're telling me? Banks are not
We're trying,
in a
yes,
position
sir.
where
That's basically
they're not
what
financing sales tax.
they're not financing the sales tax because that's becoming the hard part at the financing. So people that are trying to buy a single house dwelling like this are having a hard time making that financial burden anyway. And when they add the sales tax in, it almost pushes them out of the league of trying to get the loan.
And I'll hold to the rest of the subcommittee and Chairman Harmon, but there's like numbers underneath this to justify the 60% as to,
Yes, sir. I've got that in the bill. And the manufactured housing people will be here.
Representative Williamson has a question.
Chairman Sims, I guess that would sort of answer my question. Did you say you do have a fiscal note?
Yes, sir, we do.
And
I don't have it with me. I guess it, Jeremy, have you got it? The note, the fiscal note?
It's in the office. It's available.
Yeah, we have one available in 133 of capital.
Mr. Chairman, and Representative Kidd's bill, the next one on the list, is the same bill.
Okay. So, any further questions of the author of the bill? House Bill 80 by Representative Rice.
HB 80 by Representative Rice of the 95th, a bill to be entitled an act to amend Title 48 of the Official Code of Georgia annotated relating to revenue and taxation so as to revise provisions of law regarding state and local title ad valorem fees, to revise definitions regarding such fees, to revise the time for submitting such fees and penalties for failure to submit such fees timely, to provide for the payment of such fees over time in certain circumstances, to clarify the provisions of law regarding rental motor vehicles, to extend the period of time which a loaner vehicle may be removed from the inventory, to provide for a title ad valorem fee for leased vehicles, to clarify the provisions of law regarding the application of title ad valorem tax fees to certain title transactions, to provide for motor vehicles titled in other states but based in this state, to exclude the application of certain sales and use taxes to motor vehicle sales, to provide that no sales and use taxes shall be imposed upon state and local title ad valorem tax fees imposed as part of the purchase price of a motor vehicle or as a part of payments under finance arrangements with the dealer for the purchase of the motor vehicle, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes.
Public Finance and Policy, Chairman Ron Stevens. Chairman Rice, you want to explain your bill?
Thank you, Mr. Chairman. I appreciate the opportunity to do that. House Bill 80 is the same bill as House Bill 66, which is also in the folder. If possible, I'd like to have both 66 and 80 committed to the subcommittee, since we're planning to substitute 66 for a portion of what's in 80 right now. So that would be our recommendation if the chairman would accept that, to commit both those bills to public finance if possible.
So what was the number of that bill?
Yeah, 66.
And I'll explain the bills then.
Chairman Rice, I want to be sure I understand what you're saying. You had 66.
66 is the same bill as 80. 80 has two more provisions in it that 66 does not contain.
But
but 60, on further information today, we're going to need to have 66 available since the bill's already dropped, and we're going to substitute that for a portion of what's in 80 and put in 66 tomorrow.
But you're not ready for a subcommittee on 66?
Yeah, I will be.
I
will be tomorrow, because there'll be a sub ready tomorrow morning on it with only one provision. That's the buy here, pay here provision in it.
Questions of the author of the bill from the members?
Yes, sir.
Chairman Martin.
If I may, to the author, since I'm not on that subcommittee and won't have the chance to answer or ask the question, he and I talked about this. I know there's many provision that in this, but we're getting a lot of concern over the antique or the classic car. Could the chairman, author and chairman address that? And also, there's a portion in this bill that strikes out the deduction of the trade-in value that was part of the comprehensive tax reform last year. It'll increase the cost to the car buying public. And could the gentleman can you speak to that?
Sure. Let me just handle the antique car issue that came up. I think in the past week somebody put out a blast email across the whole state indicating that there was a problem with that in House Bill 8066. Actually, 386 last year, which is what this bill cleans up, had nothing in it about antique cars. It just happened that there was an overlay in the code based upon the implementation of 386, where there was a particular section that required that the title fee be 6.5%. Currently, the details on this are going to be in a memo I'm going to put out to the floor tomorrow that deals with this. Unfortunately, there's about 3 different code sections that this hits, and so we'll have a cleanup amendment tomorrow. There'll be in the substitute for this, but that issue will be managed. If you want to know what the issue is, I'll be happy to talk to you about it, but it's kind of detailed, and depends on how long you want to go.
Well, no, sir, I don't want to take the chairman's time. I guess what I was just giving you the opportunity for folks that sent the blast.
I think that what we'll demonstrate tomorrow is that we will assuage the concerns that they have. It just had to do with how those cars are valued. Briefly, they don't have if they meet the definition of antique or hobby car, they don't have a tax on them except for an ad valorem tax, which has the basis for valuation at $100, which means that the counties are sending out a bill for about $2 for every one of those cars, and that's all that the state collects on any of those cars. The title fee bill inadvertently would have moved that to if you sold your car the next time, next year or 2 years from now, 5 years from now, the next buyer would have had effectively a sales tax or a title fee tax on that of 6.5%. The only issue is it fair from a policy standpoint to move that title fee down to a number that more closely resembles what their business habits are right now. On the second issue was the trade-in value. Trade-in value in the original bill was mistakenly put into the second or third page of 386, and it conflicted with the definition in the first pages of fair market value. House Bill 80 treats all vehicles the same. It'll be the hire of book or invoice for both used and new cars, less trade-in, and less other things that are excluded from the bill. So that's what's in 80 right now, and in 66.
Chairman Sims has a question.
Chairman Rice, does this either one of these bills address the leasing problem?
Yes.
Okay.
Yeah, they both do.
Okay.
And that'll be after further conversations with the industry, OPB, and the governor's office. There'll be a change even to the bill, House Bill 80, in the substitute. We'll present in subcommittee tomorrow. Basically, what House Bill 80 says, we're taking the title fee down to 4% on leased vehicles. They still pay the use tax. Tomorrow in subcommittee, there'll be another recommendation to take it to 7% no use tax based upon the fiscal note, the ability to maintain the revenue over that situation.
Representative Rice, I see no further questions. Thank you. House Bill 81. Representative Dudgeon.
House Bill 81 by Representative Dudgeon of the 25th and others. A bill to be entitled an act to amend Code Section 48-7-40.30 of the Official Code of Georgia Annotated relating to income tax credits for certain qualified investments for a limited period of time, so as to extend such income tax credit, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes.
Income Tax Subcommittee, Chairman J. Powell. Representative Dudgeon.
Thank you, Mr. Chairman, members of the committee. Bring to you today House Bill 81. This is a 2-year extension of what is called the Angel Tax Credit, which is a tax credit for people who invest in startup companies here in Georgia. The original tax credit was passed 3 years ago, and we're asking to renew it for 2 years. This is a result of recommendations from a council set up by the Lieutenant Governor, who recommended this. The Governor's Competitive Initiative also recommended this for a 5-year term. This has broad support from the industry, the Science and Technology Community Strategic Plan. It's one of their top recommendations. And again, this is just getting going. The original tax credit has a 2-year delay between when you apply and when you get the actual credit. So we're just now getting data back from DOR on how this is being used. We know at least 96 companies have applied. It's very successful. A lot of our states we compete with for technology have this, and we believe it's critical for the industry.
Any questions of the author of the bill? I see none. Thank you, Representative Dudgeon. Is any further business needs to come before this committee? Seeing none, we stand adjourned. Thank you for your attendance.
Are there any subcommittees?